Hi, everyone. Okay, so this is part 2 of the speech because I ran out of time. Across all major professional bodies in the United States, supervised visitation is the standard safety measure following psychiatric hospitalization involving suicidal or filicidal ideation or psychosis. This is not controversial. It is basic child safety. Less than 2 months after Judge Valenzuela read the psychological evaluation and stated he had no concerns with him having custody unsupervised with the children, on May 19th, 2024, my fears were validated. During court-ordered unsupervised parenting time, he murdered Alec and Lydia and then died by suicide. The cause of death was confirmed as a filicide by GSWs to the head. My children were executed during mandated court unsupervised time that the courts required me to send my children to. This was a predictable outcome, and it was absolutely preventable. This was not simply an error in judgment. There were repeated and obvious markers of severe danger. As many protective parents are, I was told again and again that I had to comply. I believed the court must know what it was doing, but it is obvious now that it did not. Even though I was terrified, I followed the orders and continued to send my children. I ignored my instincts to protect them out of fear of losing time with them and angering the court. Compliance cost my children their lives, and now I will never have time with them again. One of the clearest danger indicators in my case was the documented domestic violence. Research shows that when a person with a history of domestic violence enters a manic or psychotic state, the risk of serious or lethal violence rises sharply. Prior abuse behavior is one of the strongest predictors of violence during psychosis. Another major warning sign was the documented sexual violence. Forensic and filicidal research consistently shows that fathers with histories of sexual violence or coercive sexual behavior are disproportionately represented in filicide cases. These patterns often overlap with delusions, paranoia, and psychosis, creating an especially dangerous profile. There was also the fact that this was his first episode of mania with psychosis. The court treated that as evidence of low risk, but the research shows the exact opposite. Relapse is the rule, not the exception. A major meta-analysis found that after a first episode, about 1/4 of patients relapsed within 6 months. About 40% relapsed within 1 year, and about 60% relapsed within 4 years, even with medication and treatment. This is why medical guidelines recommend at least 2 years of close monitoring and maintenance treatment after a first major psychotic episode. Beyond those factors, there were many additional danger markers that the courts minimized or ignored altogether. These included filicidal ideation, suicidal ideation, and the 9-day psychiatric hospitalization, clear delusions, removing the children from school outside of their regular routine, violating the order of protection multiple times, the high relapse risk of following a first episode, and the documented risk of medication noncompliance. Each of these is well established in forensic, psychiatric, and domestic violence research as elevating the risk of serious or lethal harm. A person with no violent history who becomes psychotic is far less dangerous than someone with a history of sexual violence, physical violence, and coercive control. Each individual factor should have been enough to raise concerns, but that combination that he had together is recognized in every major forensic danger assessment model as a high lethality profile. Yet the court did not allow even 2 weeks to pass to determine whether he was stable or safe after a serious psychiatric hospitalization. The court did not require him to provide any evidence that he was stable or safe. The court ordered full unsupervised equal parenting time during the period of highest documented relapse risk and the highest risk of lethal violence. This was all done in temporary orders. My case never even made it to final orders. My children were murdered first. The day after my children were found deceased, the court held a hearing without me. I was given no notice in time to attend that day. I was meeting with law enforcement and investigators and arranging my children's cremation. At that hearing, the court dismissed my case and sealed all of the records. To this day, I do not have access to my own records in my own case. The public does not have access either. I was told that this was done for my protection, but now I know that it was done to block oversight and to shield the court from accountability. I am the only surviving parent, yet I cannot review the record of the decisions that ordered my children to their deaths. I followed the law. I sought protection. I raised concerns over and over. I asked for supervision. I asked for verification of treatment and medication compliance. I trusted the system that is supposed to protect children, and my children, Alec and Lydia, still died. Alec and Lydia mattered. What happened to them must lead to change, Arizona. Arizona's children deserve a system that recognizes danger, responds to risk, and puts their safety first. Their deaths were the result of judicial negligence and a system that failed to protect them at every stage. Despite the pleas for safety, I lost Alec and Lydia, because the court ignored clear and present danger. But their lives will continue to have meaning because I will not stop speaking until this system is changed. In the months since losing Alec and Lydia, I have met many other parents who have experienced similar failures in the system. What happened in my case was not an isolated mistake. There is a consistent pattern in Arizona where clear safety risks are minimized and unsupervised parenting time is ordered even when there are documented red flags. My children were murdered and many others are being placed in unsafe conditions under the belief that parental rights should outweigh child safety. No child should ever be put in risk to honor a parent's rights. Let Alec and Lydia's story lead to change that protect children. Let justice finally mean protection. Thank you for allowing me to speak on behalf of my two beautiful angels, Alec and Lydia Mader.